Thanks a lot. And now I will take full responsibility for the slides as I'm now coming into my own slides. What I basically want to do when, well, it's after lunch and we've been enjoying the good weather. So I think you should have a case study. So that will be the core of what I will be presenting. But before coming to the case study, I want to just put IPR enforcement into some kind of framework, an overall view at some principles that applies to this piece of very international legislation. And if I have time, I've made a checklist for myself that I use if I look at a trademark and a copyright case. And if I have time, I will go over that. And if I don't have time, you will have the slides, and you're most welcome to do that. I'm developing it also now for design, but that's another matter. So looking into the European Union intellectual property enforcement legislation, we have to go back to basically what Tobias was talking about this morning, the overall international framework that this has been built upon. And I've tried to illustrate it with this drawing here. The international creation of the framework for intellectual property rights protection was created in the late 1800s. We got the Paris Convention for industrial rights, and we got the Berne Convention for copyright. These two conventions set off a 100-year development of the international framework. More and more conventions, agreements came on top of these two fundamental agreements that tried to bring up some alignment of the principles for protection of intellectual property rights in the international field. We got new instruments. You could apply for an intellectual property right in one country, have the application transferred to another country, and so on and so on. We created a big international framework for protection. But what about enforcement? Well, many of the conventions have a short article saying something about, well, this legislation has to be backed up by effective enforcement, but there was not really any detailed requirements in the legal framework. So basically, built on these international conventions, national legislation evolved about how to protect an intellectual property right, if there was going to be registration, how was that going to be carried out, and what was the scope of protection, what would be the requirements to find that there is an infringement. That was all built in this framework. Enforcement was left more or less completely to the individual country. So all the members of the Berne and Paris Conventions created their own take on the principles of enforcement of intellectual property rights. But something happened. Two major developments, maybe three, but two major developments came that changed that fundamentally. The first one was the collapse of the Soviet Union. The collapse of the Soviet Union released the world from the stranglehold of the Cold War and opened up for a new development in free trade that had been, up until that time, unthinkable. It also opened up China and many Asian countries, and of course added on with technological developments the easy accessibility of shipping services, postal services, and so on. This opened up to a new world. To facilitate this free trade, as Tobias mentioned, we got the WTO agreement, and as part of that, the trade-related aspects of intellectual property rights agreement. What was the idea behind this was basically that the industrialized countries of the world, they said, well, if we are going to open up for free trade, we want to ensure that the principles for protection and enforcement of intellectual property rights meet a certain minimum standard. Because what would be the price of a big industrialized country if we got completely free trade but no minimum requirements for intellectual property protection and enforcement? Well, we would basically open ourselves up to be undermined by competitors misusing the intellectual property rights that has been so essential for many industrialized countries' industries. So to have a balanced international world trade, it was necessary to come up with these minimum requirements. The other thing that happened that had a big impact on the world was the development of the international payment system between the banks. Slowly, in the beginning of the 1990s, the international cooperation in the banking sectors intensified, and it became easier to make instantaneous financial transactions. Now, the third thing is, of course, the emergence of the internet. And today that has almost surpassed the first two in importance. But it was not the main driver behind the TRIPS Convention. Actually, the TRIPS Convention, of course, also applies to the online environment, but it doesn't really specifically deal with the challenges that has come in that environment. So I would say it was not really the driver behind the TRIPS Convention, but of course today it's of extreme importance. Now, the TRIPS Convention has a lot of substantive rules about protection, about scope of protection of different rights, about minimum requirements for when infringements are going to be found. I'm not going to touch upon that. That has now been implemented through a number of regulations and directives into the European Union legislation and so on. But there are, for the first time in international legislation, a number of minimum requirements concerning the enforcement. And basically, the TRIPS Convention identifies 4 different areas of enforcement action. Civil enforcement, where 2 parties struggle with each other and at the end of the day uses the civil court system to resolve that conflict. Border measures, the use of customs forces or other border forces to do action against suspected infringing products. Administrative enforcement, this is the part that fills the smallest part of the TRIPS Convention, but basically setting a very few principles for administrative enforcement. What could be administrative enforcement? Well, many countries will have some kind of market surveillance unit. They would have some administrative organ under government that has some authority to do action against infringing products, and that will fall under that category. And then there will be criminal measures, basically where law enforcement, mostly police forces, launch an investigation and delivers the case to the prosecutor that then brings the case before the courts as a criminal procedure. These are the 4 areas that is identified in the TRIPS Convention as enforcement tools. Now, the civil part of the TRIPS Convention is the most detailed part. That's where most rules are defined. And they have been implemented into European legislation through the Directive on Enforcement of Intellectual Property Rights, the Directive 48 from 2004. Now, there are now discussions about updating the directive, but it has shown itself to be a rather resilient and I think rather successful directive. I remember back in the 1990s when the WTO agreement and the TRIPS agreement were going to be implemented into Danish legislation. Then later came the directive, but there was an implementation of TRIPS already at that time, and it was very controversial. And why was it controversial? It was controversial because it introduced some legal instruments into civil enforcement that was to a large extent unknown. They came from legal traditions that was certainly not reflected in what was the normal principles for civil enforcement in Denmark and in a number of other countries. One of the things that was developed was the preservation of evidence. And that basically made a requirement that it should be possible to a very invasive legal measure to gather evidence at a supposed infringer's place of business. And that was very controversial because many felt that that kind of measure would go very close to a criminal procedure. By going to a court, getting a court order, doing a search of a place in a purely civil conflict was taking things rather far. Some of the other principles were also felt to be very, very invasive and very strong tools. Some of the injunctive reliefs and rules for damages and so on. Now all of this has, of course, the debate has calmed down, everybody has accepted these principles, and today we have in the directive what we can call a TRIPS plus standard. It goes for actually all of these enforcement measures that in the European Union we have gone further than the minimum requirements of TRIPS. Of course, there is this development agenda to this that, of course, we are a highly industrialized area with a highly advanced legal system, with long-standing traditions for fairness of due process of law and all those things. And of course, there can be countries in the world that are not able to apply these TRIPS plus standards. But we have done it here in the European Union through the directive that puts up a number of tools and makes them available for enforcement action. The border measures are extremely important when we are talking about intellectual property rights enforcement, and the reason for that, of course, is, as I mentioned before, the amount of IPR infringing products that are being shipped over borders are very, very large. It's a large percentage of world trade, and that means that that is a very effective place to do enforcement action. Just imagine, you have a factory somewhere in Asia that produces counterfeit products, and they are now imported into a European country. After the importation, the products are being spread in thousands of different shops. In principle, it's very, very difficult and cost-intensive to be running after the products in 1,000 shops. But if you can attack at the point of importation, it's a much more effective measure. So this is very, very important, and we've had 3 regulations on the subject, and the last one came in 2013, basically expanding the scope of customs action quite substantially. Now, we have to remember when we're looking at the customs regulation, it is simply building on top of civil legislation. You have to have an intellectual property right. It has to have been infringed in accordance with the rules of the substantive laws, and then comes this on top. There have been cases where people have argued that the customs regulation creates an extra scope of protection. But that's not like that. It will always require, using these tools, that all the basic requirements for having a right protected and having an infringement in the substantive laws have to be met. In regards to administrative enforcement, TRIPS sets out, and it is followed in the Civil Enforcement Directive, that if measures are put into national legislation, they have to comply with the basic principles of civil enforcement. That doesn't mean every little procedural detail has to be replicated, but the basic principles has to be applied with. This is an area where you can say that a lot of freedom has been put into each member state to put up administrative enforcement. Some countries have a lot of administrative enforcement, and some hardly have any at all. For Denmark, I can say we have hardly any administrative enforcement at all. The only thing I can come up with that is a little bit like administrative enforcement would be the food agency's control in regards to geographical indications. That would be the only thing that would get close to administrative enforcement, where other countries would have market inspectorates that actively go and do action against IPR infringements. This question about going further than the EU legislation was up in a case before the European Court of Justice. It was a case from one of your neighboring countries, from Estonia. There was a company called Syntax that imported bottles of bathing products into Estonia. Customs seized the goods and got an opinion from a patent holder called Acera, and they confirmed that the goods infringed a patent that was held by Acera. The customs suspended the release of the goods based on an administrative customs decision in accordance with national legislation establishing patent infringement. Syntax, the importer, brought a court action against the customs, arguing that civil action had not been taken within 10 days in accordance with the customs regulation. So basically, the issue before the European Court of Justice was, can Estonian legislation put in a regime where customs can do an action that goes further than the customs regulation? We have a case where we have the right holder confirming a patent infringement, but are not supporting the action. They are not launching the civil lawsuit within 10 days as requested in the customs regulation. Now the question was Estonian law contrary to EU law? And basically what the European Court of Justice does here, they look at the principles of the customs regulation, then they say, well, it is okay for national legislation to go a little further, but national legislation has to comply with the principles, the basic principles of the customs regulation. And that's exactly the same logic that we find in the TRIPS Convention about administrative enforcement. You could really argue that this was a kind of administrative enforcement that had been put in place in Estonia, going further than the minimum requirements. And one thing that's very important from the European Court of Justice here is that they say, and there has to be a legal remedy available, so there has to be the opportunity for Syntax to bring the case before a court of law. But after that, it was accepted that national legislation went further than the minimum requirement. The history of criminal enforcement has been a long process in the European legislature without being resolved. After we got the Civil Enforcement Directive in 2004, a proposal for a minimum requirement criminal procedure directive were put forward by the Commission in 2005, updated in 2006, and withdrawn in 2009. There was a big constitutional discussion. Could the EU make minimum directives concerning criminal law? That issue was resolved later in 2009 with the Lisbon Treaty, opening up that minimum requirements could be made in EU legislation on areas covered substantially by the EU. And here we have, for most intellectual property rights, as part of the substantive legislation. So yes, now it's possible. But there has been no relaunch of such a directive. There was, however, a negotiation of the anti-counterfeiting trade agreement between a number of countries, the so-called ACTA, and the EU participated in that as well, and there would have been stronger minimum requirements. But the ACTA treaty was rejected by the European Parliament and has not come into force as a working legal instrument. So basically, the minimum requirement from TRIPS on EU criminal legislation is the one that is put in TRIPS Article 61, which simply says that willful trademark counterfeiting or copyright piracy on a commercial scale shall be punishable, and the sanctions available should be imprisonment and or monetary fines. Then, of course, destruction and seizure and destruction of goods. But basically that means that national legislation, if it only has a fine as the maximum sanction, that will still be compliant with EU law. That is a very low level, and most EU member states will have imprisonment available for the more serious intellectual property rights infringing cases. Now, we constantly meet these terms, and they create a lot of confusion, and I'm very sorry also when I was doing my presentation this morning, I was using a little bit the word infringement and counterfeiting a little bit synonymously, but they are not. They have a substantive legal difference, and it has a consequence, because certain enforcement tools are only available for counterfeiting, and others are available for all kinds of infringement. So what is the difference between this? Well, civil enforcement tools are available for all kinds of infringements. Administrative, the same, because the principles that applies to civil has to apply to administrative, so this principle also applies. But when we are looking at criminal and border measures in TRIPS, they are using the word counterfeiting. And counterfeiting is a subgroup of infringement. So everything that is a counterfeiting is an infringement, but not everything that is an infringement is a counterfeiting. Very often people use the terms synonymously, but there is a substantive difference. And some of the tools, especially some of the new and interesting tools we also heard about earlier today with goods in transit, here the distinction applies. If we take the trademark, substantive trademark protection, we are talking about similarity and likelihood of confusion. That's the test that has to be applied to find out if a supposed infringing mark is infringing on a registered trademark. But if you look at TRIPS, the definition of trademark goods, they are talking about goods which cannot be distinguished in its essential aspects from a trademark. The infringing mark, to fall under the category of counterfeit, has to be almost the same, essentially the same. And this is a more narrow definition than the similarity or likelihood of confusion. If we take the new customs regulation in force in the European Union, it uses precisely the same terminology as the TRIPS Convention, so it applies directly to European Union enforcement on border measures. Now, this was up in a Danish case where I think the Danish Supreme Court really put it quite beautifully. There had been a customs seizure of some products that supposedly was infringing the diesel trademark. Diesel has some strong trademarks, but there was a mark. It was not identical or almost identical, but you could discuss whether there was similarity and likelihood of confusion. And here, the Danish Supreme Court, by looking at this case, say, intervention under the old customs regulation presupposes identical or nearly identical marks, which would imply a narrower scope than that which would result from trademark law similarity and likelihood of confusion. And then they acquit the supposed infringer here, and the goods are released into free circulation. So here, basically, the Supreme Court uses the distinction as a practical reality. Today, this distinction has direct effect on the small consignments procedure that the customs have and the goods in transit. We heard this morning that we have this new expansion of trademark protection, and it's going to be a very important expansion because basically the customs officers will be able to take action against goods in transit on the way to a third country if they are counterfeits, not infringements. The test has to be a little higher. And then the only way to get the products released will be if the supposed infringer, the holder of the goods, can document that the trademark is not protected in the country of final destination. So the burden of proof have been turned around. But here there's a practical reality. And also for criminal procedure, it's a practical reality. The minimum requirement under EU law is simply counterfeit goods, not infringements. So I can tell you the way we administered it in Danish prosecution is basically the law reflects that all infringements are punishable, but in practice, criminal cases will only be launched when we have to do with counterfeit goods. The infringement has to be quite clear for a criminal procedure to be launched. So I'm going to come with my case example now. This was the framework. We have an advanced legal framework with a lot of details, putting up minimum requirements for enforcement. I'm going to show you a case example from the Danish Supreme Court of a civil enforcement case. As all case examples, I'll just go over the principles in the Civil Enforcement Directive for us to reflect how they were actually applied in this case. Well, the Civil Enforcement Directive says that our enforcement has to be effective, proportional, and dissuasive. Without prejudice to other legislation, there should be safeguards against abuse. We should not create barriers to free trade. Cases should be resolved without unreasonable time-limited or unwanted delays. They should not be unnecessarily complicated or costly, and they should be fair and equitable. Basically, these principles, and they are all, of course, a little bit potentially in conflict with each other. So a fair balance has to be struck between all these interests. We have to have effective, cheap, quick enforcement, but it also has to be safeguarded against misuse. And then there are the different tools available in the directive, provisional precautionary measures of injunction and seizure, a procedure for right of information, measures for preserving evidence, corrective measures, injunctions, and minimum requirements for payments of damages and legal costs, and the possibility of having the court ruling made publicly available. Now, the directive should have as wide a scope as possible, and that has been implemented through a statement by the Commission that basically have stated that all known intellectual property rights has to fall under the directive. So the directive doesn't say which intellectual property rights should be covered, but it is the view here of the Commission that all intellectual property rights should be covered. But it's a minimum directive, so it can also apply to other acts, and many countries have made the tools available for acts involving unfair competition, parasitic copies, or passing off, or similar activities. Also violations of trade secret and so on for some countries have expanded. But on the list here we have the rights that has to fall under the directive. Now the case I'm going to go over started in the Danish Maritime and Commercial Court that came up with a ruling on the 15th of April 2010, and that was upheld by the Danish Supreme Court in 2012. And the reason why I chose this case is it is kind of a breakthrough case in the way that this was the record-breaking court ruling for payment of damages. It was the highest calculation of damages that had been seen up until that time. very often in cases the damage payments had been relatively low. But here there was a big breakthrough of really a court order where very substantive damages were being awarded. The conflict were between the New Balance company and the bestseller company. Of course, I've simplified the case for the presentation here. Now, the right holder, and I'm not going to go so much into the substantive IP issues here because the court found that there was a violation, so that's really, I'm just going to look at the procedural part of it. I'll call the New Balance company for New. The New Balance company is a very well-known company. My wife used to be a champion in triathlon, and she'll never run in anything but New Balance. So it has a reputation for being very high quality, very good quality sports shoes. It was a company founded back in 1906. It really took off as a major player in the sportswear sector in the 1970s. And at the time of the court case, it had grown to worldwide sales exceeding 1.3 billion euros. And at the time, it was the 9th largest producer of sports shoes. Now, the defendant in the case was the bestseller company. I'm abbreviating them BEST. BEST was a company founded in Denmark in 1975, specializing in clothes targeting young people. The brands produced by BEST, I'm sure many of you will be familiar with the brands. They are certainly for sale here in Latvia: Jack & Jones, Limited Only, and Veramoda. At the time of the court case, worldwide sales exceeded 2.6 billion euros, the double of the New Balance company. This is the case history. It starts in November 2006. New requests that a preservation of evidence is carried out against the bestseller company. They had found that certain shoes were being marketed by the bestseller company in violation of their rights. In December, New Balance requested an injunction and right of information, and the action, the preservation of evidence action, was carried out at the bestseller headquarters and on the 19th of December 2006, and the court ordered right of information, seizure, and an interlocutory injunction against the sale of these shoes that was being produced by bestseller. The day after, made bestseller the claim that they had stopped all sales of the contested products, but just a few days later, New Balance was actually able to document that some of the products, the supposed infringing products, were still for sale in retail shops in Denmark. In January 2007, did the bestseller company acknowledge the legitimacy of the court orders and declared to have stopped all production and marketing of the contested products. And a little later, New Balance were then able to document that there were still sales going on of the contested products in shops outside of Denmark. And that's finally stopped in the middle of March 2007, where all sales of the supposed infringing product had now stopped and all products had been removed from the market. Following that, a lawsuit was made in July 2007 against bestseller with the claim for damages. About 3 years later, the commercial court rules partly in favor of New Balance, and the ruling was appealed by the bestseller company, and it went before the Supreme Court. 2 years later, did the Supreme Court uphold the ruling. Now, one of the things that we saw in the directive is that the procedure has to be quick and without no unwarranted time delays. And I don't think anyone can say here that there is a logical procedure here, and everything comes without any very big time delays. Of course, it takes some time before the case to come before the commercial court, but overall, a period of less than 6 years is not uncommon in cases like that. Of course, it'd be nice if it could be quicker, but it's also complicated issues, and many evidences has to be collected and presented. So I think 5-6 years is not completely uncommon in cases like this. Now, the directive sets up some principles for the calculation of damages. And they basically say that all appropriate aspects shall be considered by the court, including economic factors, negative economic consequences for the right holder, lost profits and unfair profits of the supposed infringer. And in appropriate cases, non-economic factors can be taken into consideration as well. And there is the possibility to calculate the damages as a lump sum based on different information, including amount of royalties or fees due to the infringer if that had been a possibility. And then there is a provision about the awarding of legal costs. How did the courts look at this? Well, here you have the products under scrutiny. We have the original products from the New Balance company is number 5, and the Grounder High. And the supposed infringing products are the JJ Stan and the JJ Slick. Of course, in the case materials, there's all kinds of details about how these were. Now, New Balance had a very successful period in the mid-2000s. And in Denmark, they doubled their sales from 2005 to 2006. But their sales only rose with 6% in 2007, the year in question. Now, Bestseller produced 13,000 JJ Slick and 21,000 JJ Stan in all 34,000 pairs of shoes in 2006. They sold 7,000 of the first one and 12,000 of the second one, in all 19,000 in the years of 2006 and 2007. The rest, the last 15,000, some were destroyed by mistake and some were taken into custody during the court actions that we saw in late 2006. There was one more thing that was under scrutiny here, and that was a marketing website and a brochure that had been made in 300,000 copies containing infringing marks. And I'm going to show you here, this is a fragment from the Bestseller webpage. We can see a very elaborate piece of marketing material, and here we have a new, there were more than this one, but I'm just showing this one example. This was a trademark, a word mark that had been protected by New Balance, and that was integrated into this marketing material, and it was also integrated in the brochure. Now, New Balance claim for damages were the following. They said, we base our claim on a rate of substitution 1-to-1. So every time Bestsellers sold one product, we lost a sale of one product. So we had a complete loss, 1-to-1. And they could substantiate that by looking at the decrease in their in the growth, where they had been growing extremely well from 2005 to 2006. Then it stopped in 2006 to 2007. The growth was reduced substantially. So they argued that they had a 1-to-1 loss. Well, the prices of the New Balance products were the double of the Bestseller products. So the Bestseller products were sold at half price if you compared it to the originals. And we look at the turnover of the infringing products. If we took basis in New Balance prices, there would have been a turnover value of $2 million. euros. And bestseller had, in fact, a turnover of around 1 million euros. The profits in this sector are quite good, so normally a profit would be around 60% of the turnover, and that would, if we use New Balance prices, be 1.2 million euros, and in bestseller prices 600,000. Then New Balance claimed a license fee, even if New Balance does not license out. They said the normal license fee in this sector would be 10%, so they made a claim for 10% of the turnover of 2 million, a claim for 200,000. And a market disturbance of market equivalent to license fees for trademark use on the website and the brochure of 80,000. An overall damage claim of 1,480,000 euros. But then they said, okay, we acknowledge that the prices of bestseller were lower, so if the court is not going to award us the full damages, at least they cannot go below the same calculation based on the prices of the New Balance company. So they made a claim of not less than 780,000 euros and up to 1,480,000 euros. Now, with no big surprise, bestseller objected. And they said, well, the rate of substitution is substantially less than 1-to-1. We cannot automatically say that New Balance lost a sale every time we were selling one pair of our slick shoes. And they contested the whole calculation and said, but we acknowledge we should pay a license fee. That's okay. And that should be 5%. That was what they would find fair, to pay a license fee of 5%, calculated on their own prices. So 5% of their turnover of 1 million euros would be 50,000 euros, and they acknowledged to be paying that. Now, okay, now we have a claim from the right holder of almost 1.5 million euros and an acknowledgement of the defendant here of 50,000 euros. There is, well, we can acknowledge there is quite a span here. The Commercial and Maritime Court ruling was upheld in appeal. And the court set a lump sum damages based on bestseller's turnover, New Balance's lost profits, and bestseller's unfair profits, and awarded 300,000 as lump sum damages. Then, concerning the website and the commercial brochure, they set a license fee of 100,000 euros, making it a total calculation of damages of 400,000 euros. A record-breaking, at that time, a record-breaking sum in an intellectual property rights case. So basically, the court ends up finding a little bit of a middle ground behind. This is actually half of the calculation. If we saw the New Balance claim calculated on bestseller prices, this is around half of that, and substantially more than what would have been the damages if it had been built on the calculation presented by the bestseller company. And then the court additionally declared previous provisional court rulings valid, made a permanent injunction against the marketing of the infringing products, ordered the destruction of seized goods, ordered bestseller to pay all legal costs, and ordered the ruling made publicly available. So basically, if we look at the tools in the enforcement directive applied here by the courts, it really gives a coherent, complete set of tools available for a right holder to fight his cause, with all these different tools actually applied. The only thing in the directive that wasn't applied was the presumption of authorship of copyrights, because copyright was not an issue in the case here. So I think the case example for me shows a successful application of the directive. Of course, it's been implemented in legislation, but one thing is legislation, does it work in practice? And here is really, I think, a good example that you can get this system to work, but everything is connected here. It is the availability to gather the evidence that makes it possible to stop the activity and to then make a very detailed calculation of the claim for damages, because it's the evidence that is found at the bestseller production site that is able to document the number of products that have been produced and the channels from where they have been sold. So it's possible to, with this clear evidence, to go to court and make this kind of claim. So I see this as just, and of course, there's many other very good examples from case law history, case law all over Europe. But I was quite impressed with this case when it came out, that it really illustrated a well-functioning system. I think I will leave this. We are not gonna go over time here. Please look at my slides if you want to. I have made up some suggestions about a remember this list if you want to, but I don't want to go over time in any way. But I'd really like to have a comment, and maybe also from Andreas here, a comment from Germany setting this Danish case example in some kind of perspective. Maybe the microphone to Andreas.
I have no comment to that.
You have no comment? Well, okay. Then I think we can conclude that this was a very instructive and positive case example. Thank you.